Mutually agreed terms, or MATs, is a term that we find under the Convention on Biological Diversity and also under its Nagoya Protocol on access to genetic resources and benefit sharing. And it mainly entails a situation where prior informed consent has been obtained and the terms of fair and equitable benefit sharing have been agreed. And both conditions for access and the modalities of benefit sharing are then encapsulated in a legal document. Very often, mutually agreed terms are a private law contract, and that's really important because on the one hand, we have international obligations related to access and benefit sharing, but on the other hand, we need legal obligations that are binding in a domestic or local context, particularly when the actors who are obtaining access to genetic resources and sharing benefits are private actors. So either researchers or private companies. So a contract is really the legal form that is needed for those international obligations to then become binding on actors other than states. However, in practice, we have several forms that mutually agreed terms can take, and it may also be administrative tools, not necessarily only private contracts. And there's quite a lot of discussion still among CBD parties as to how to make them really effective in clarifying the obligations of the respective parties, so creating legal certainty in their relationship, but also ensuring that there will be effective access to justice, including in different jurisdictions, if anything in the relationship does not go according to plan. And so there is work ongoing under the Convention and the Nagoya Protocol, looking into, for instance, the development of standard contractual clauses, but also trying to understand the practices of different groups and stakeholders that are particularly involved in the conclusion of mutually agreed terms. So certain sectors of academic research, as well as maybe those working in the development of medicinal products as opposed to food products. And of course, there's quite a lot of open questions still to be clarified, including questions related to private international law, how these contracts will be recognized from one country to another, and how they will or not facilitate access to justice in different countries. Interestingly enough, mutually agreed terms is also an expression that we find under international human rights law, and that's very much to do with prior informed consent and benefit sharing with regard to the use of natural resources that are found in the lands traditionally used or owned by indigenous peoples and local communities. So once again, this is an area where the Convention on Biological Diversity and international human rights law look at the same concepts in the context of more traditional natural resource development.